Okay, good morning or good afternoon or wherever you're based. I hope you're well. We are very pleased to be with you, if only on YouTube, today to discuss a subject that you may have heard about, but I'm confident that you will get to some answers and some thoughts that you probably never heard before. So for that reason, I'm really excited to be with you today. I will be moderating the panel. My name is Thibault Schrepel. I'm an assistant professor in Antitrust at Utrech University. We have two speakers and one debater with us today. And as I just told them, I will shortly introduce the three of them to make them uncomfortable. So I'll start ladies first. Of course, I will start with Laura. So Laura is an assistant professor at the University of Warsaw at the Department of European Economic Law. She has been a visiting research fellow at the Max Planck Institute in Munich and also at the Berkman Klein Center at Harvard University. I first met Laura in 2017 in Italy, in a small city called Lecce. And since then, I've been following everything she's been publishing, and a lot has been about the subject of digital antitrust. So Laura, it's a real pleasure to be with you today, and I very much look forward to our discussion. Then we have another speaker, Frédéric Marty, which I've also met a few years ago. Frédéric is a CNRS senior research fellow and affiliate researcher at the French Economic Observatory, which is hosted at Sciences Po Paris, and also a member at the EPPP research group at the Sorbonne Business School University. On top of that is a member of the Collège of the French Competition Agency. I met Frédéric in 2016, actually, right after I defended my PhD. I think it was the first, at the time, Skype video call that I had after my PhD defense. But in fact, I was already reading Frédéric's work for several years. So it's also a real pleasure to be with you today. And our debater is Juliano, and I hope I will pronounce your name correctly. Maranhão, is that the way to say it, more or less?
It's very close.
Very close, okay.
Well done.
I did that a lot, so. Juliano is a professor at the University of Sao Paulo at the Faculty of Law, and most specifically at the Department of Legal Philosophy and Legal Theory. He has been working on the issues related to digital antitrust for quite a while, but here's the catch. Juliano is one of the rare scholars all over the world with a technical expertise. I was actually surprised to learn this morning that he was a postdoc at Utrech University, where I teach, and he was at the School of Informatics there. He's also a member of the International Association for AI and the director of the Law and Algorithm Association for Research in AI. So I'm also very pleased to be with you. We met last year in Sao Paulo, and again, it's great to be reunited today. Here's the program. We do have more or less 2 hours in front of us, and we have decided to divide the session in two pillars. During the first part of the session, our two speakers will present a topic which is related to digital antitrust. They will get 15 minutes each. After that, Juliano will comment on the two presentations for about 10 to 15 minutes, and we will give back the floor to Laura and Frédéric for them to answer if they have anything to answer. That will be for the first part. For the second one, we will be moving into the discussion, and I've sent them already 3 questions, but no worry, they are so complex that in any case, it's not, a right or wrong question. And I have no idea what they will answer, but we will do that in turn, and all of them will get a chance to answer my 3 questions. Without further ado, thanks again, welcome, and thank you for being with us today. And I will give the floor to Laura first. If you want to share your screen, you should be able to. If it's not working, please let me know.
Thank you very much, Thibault, for the very nice introduction. I'm also very much looking forward to discuss with you the challenges that digital markets indeed raise from a competition law perspective. So very quickly, what I intend to present today is my ongoing research on data sharing and data access. And I try to tailor my presentation considering indeed also the most controversial aspects and questions that EU policymakers specifically are trying to address when it comes to the relation between competition and regulation in this kind of field. So the majority of the audience is composed by competition law experts, if I have understood well, so I will go quite quickly on the basic point just to raise a few general questions I would be glad to discuss together. So very, very quickly, the key point, the final outcome I would like to address is data availability. What do I mean? That, of course, the reason why increasing data availability is one of the priority of the European Union data strategy, also looking at the last, let's say, step of it published in February 2020, is of course that increasing data availability, we can increase the value of the European Union data economy by incentivizing, fostering data-driven innovation. So the starting point is that we need to increase data availability within the EU internal market. And of course, we can adopt several different lenses to address such a specific challenge. And in my presentation of today, I will quickly try to discuss together what can be the role for competition law first, and what can be the role for regulation, looking at the current, let's say, policy scenario. Again, my perspective is a EU-oriented, but I will be glad to discuss further models coming from different regions and countries, and what can be the role for competition law in this scenario. So in light of these very quick premises, I will start trying to frame together what is the current role of competition law in the EU scenario in order to foster data availability. And I have to say that this debate is kind of old. I mean, we all know that per se antitrust law should intervene ex post, so it should never impact on the structural characteristic of the market. So both antitrust law and authorities cannot indeed intervene in order to lessen the cost for accessing data. The two scenarios, the two pieces of the competition law puzzle we can consider when we try to address data availability and access in light of competition law are well known to everybody and can be quickly addressed. Why? Because when it comes to the first of the two pieces of the puzzle, we can agree that under specific condition, a dominant firm can indeed be mandated to share and provide access to a specific facility, and we can try to figure out if data can fall in the definition of facility. The debate, I want to stress this, is quite, let's say, old or better. We have some sort of common understanding in the antitrust community about that. And in this case, we can consider about the application of essential facility doctrine toward data. And if we consider, let's say, the availability of data, the increase of the availability of data via agreements, via private players agreements, we should, of course, apply the horizontal guidelines. So very quickly, the first of the two categories, the one of essential facility doctrine, can be tested toward data, but we should consider the difference between data as an asset with the traditional essential facility for which the theory has been indeed developed. So the intrinsic characteristics of data are making it very controversial and difficult to find the application of the essential facility doctrine toward data. I quickly reframe three of the major characteristics of data as an asset, which indeed help us in, let's say, framing the application of the essential facility toward data. I just added a few bibliographical references in these slides because we can, of course, find studies trying to apply the essential facility doctrine toward data. And of course, the answer always is we should proceed with a case-by-case assessment, checking if we are in front of a dominant company, which is holding an indispensable data set, which indeed is excluding some effective competition in the downstream market and is preventing the introduction of a new product without an objective justification. However, and again, borrowing from the works of the authors I'm quoting in the slides, but more broadly, trying to connect my previous slides concerning the characteristic of data and the slide concerning the requirements we should verify in order to apply the essential facility doctrine, I think we can easily agree that data per se can very rarely, and better data sets, can very rarely satisfy the full requirements for the essential facility doctrine. So that to say that the role of competition law when it comes to potential dominant companies holding, let's say, crucial data set for the market is extremely narrow. Again, we should proceed with a case-by-case analysis. So we cannot exclude this per se, but the recurrence of the full requirements as they are, so as they've been developed, thinking to completely different essential facility, do not fit well the data economy. And we can proceed with a similar reasoning also if we address the second of the two pieces of the competition law puzzle. As I define it, it means the horizontal agreement, because for sure we can think about agreements that indeed are establishing some sort of standardization in the data economy. So we can also think about the application of the so-called safe harbor set by the horizontal agreement, by the horizontal guidelines of 2011. So that's just to say that, of course, we can also consider an increase of data sharing and access via horizontal agreements. And if we consider agreements concerning indeed data in a given market with a reference to a given service or within an ecosystem, we can think about the category of standardization. And then we can apply the horizontal guidelines, and specifically, we could think about relying on the safe harbor established by the horizontal guidelines of 2011. In particular, we have a safe harbor established in the standard setting agreements per se are pro-competitive, except in specific circumstances that you all know and that are listed in this slide. So again, my finding is always the same, is that we need a case-by-case assessment to verify if agreements, horizontal agreements, indeed incentivizing, fostering data access and sharing among players operating in a specific industry or market are or not licit. So if such a tool can be conducive to a data access and data sharing. And another point we can discuss as an outcome of this very, very quick overview is about the opportunity of reviewing or not the horizontal guidelines, so to consider what we have defined in several different discussion among antitrust scholars as the so-called data pools. So is there a need to review the current rules or not? But more specifically, just to summarize, in my opinion, if we think about the role of the current, let's say, competition laws set of rules toward the increase of data access and data sharing, we can consider that both the essential facility doctrine and the safe harbor established by the horizontal guidelines are covering a small role in this specific scenario. So what about the role for regulation? So we all know that the European Commission and the European institutions proceed with what we can define a sectorial fragmented, piecemeal approach. A lot of definition have been used by the literature. And of course, this approach depends on several factors, including the typology, the type of data, personal, non-personal, public, research data, and so on, but also who is the data holder, who is the data user, and so on. So just to make a quick overview of those measures, we can identify several different hard law and soft law tools adopted in the last years by the institutions that indeed produce an impact on the scenario I'm framing. Why? Because in concrete terms, they impact on the increase of data availability within the European Union internal market. So of course, if we start from the free flow of data regulation, which can be seen, let's say, as the complementary piece of regulation for non-personal data, which is establishing rules partially corresponding to those established by the General Data Protection Regulation, the combination of the two pieces of regulation is indeed pursuing the goal of increasing both the free flow of data and, of course, when it comes to GDPR data protection specifically. So what are the tools that they introduce when it comes to the free flow of data regulation? We can easily agree that the main measure and the main tool is the ban of data localization obligation that can produce an indirect effect of increasing, let's say, increasing the tools in the hand of data holders that would like to share and make access and make their data accessible. If we look at the GDPR, we can find several different tools that produce an impact on the framework I was quickly describing. And again, we can find also specific rules concerning different nature of data, in particular the Open Data Directive, which updated the PSI directive, specifically focused on the obligation to offer public sector information for the reuse. And we also can rely on a couple of soft law, or better, not binding tools adopted by the European Union that in concrete terms have a secondary impact on the increase of data availability in the EU. I'm thinking specifically to the guidance of private data sharing that is already a quite dated document because it was published in 2018, that in concrete terms is just establishing some sort of toolkit, toolbox of legal, business, and technical aspects that companies, private players, and business to government relation can be adopted to facilitate and foster data sharing. And similarly, we can refer to the recommendation of scientific data, which indeed is moving in the direction of fostering open access policies. So this is just to quickly describe what is the regulatory framework, which already is, let's say, ongoing, and which can be seen as the regulatory framework which is producing an impact on my question, how to increase data availability in the European Union. And of course, we need to consider also the last pieces of the puzzle, considering first of all the European data strategy of February 2020, where the European Commission is establishing a lot of priorities that should be better developed partially this year and most likely next year. And particularly, we can find this definition of European data space that the European Commission would like to establish as a market, single market for data, where indeed we do have an increase in the data availability and easy access to amount of high quality industrial data. And specifically, the Commission is stressing this idea of having a huge amount of data available, not depending from the type, so non-personal, personal, business to business, business to government, government to business. And the first, let's say, step of the European strategy for data, the first proposal adopted among those framed within the European strategy for data is indeed the Data Governance Act. So the proposal of the Data Governance Act published last month, which indeed is pursuing 4 main goals. And again, we can see that it's still maintaining a distinction between the types of data. In particular, I consider very interesting that when it comes to public sector data, there is this idea of moving even beyond the Open Data Directive by making public sector data available, even in case in which third parties can invoke rights on this specific data. When it comes to private held data, there is this idea of access against remuneration. And when it comes to personal data, there is this plan of introducing an intermediary to facilitate the use and to facilitate the users in their personal data sharing initiatives. Of course, this is still a proposal, and we don't know yet specifically how it will be implemented and adopted. I will go quickly because I don't want to exceed my time, and I know that all these aspects will be reframed in our discussion. So just to conclude, we can, I think, share the starting point, which is there is a need of increase the data availability within the EU internal market. Looking at the current scenario, in my opinion, competition law per se covers a residual role. We have seen the 2 main categories under discussion within our academic stream, and still we can consider that they do not cover, let's say, disruptive role in the increase of data availability. If we check the measures and both of hard law and soft law adopted by the EU policymakers and regulators, we can see a quite straight and sectorial approach. So we have piece of regulation depending on the data holder, the data user, and the nature of data. And a lot of questions are still open. And of course, we can discuss if there is a need of updating the existing competition law, the guidelines of 2011, the specific debate on the essential facility doctrine and the need to revise it. We can discuss about, and there is an ongoing debate on the opportunity of introducing an obligation to data access at specific conditions. But I want just to conclude by adding that, in my opinion, a category we should, let's say, bet on are the so-called European Union data spaces that have been defined by the European Commission in the 2020 data strategy as indeed this governance structure that should represent the perfect balancing act between the interest that both private and public players have toward data availability, share, and reuse. So I think I already exceeded my time, so I will not, maybe I will use the debate part to better frame this specific suggestion I have, because I truly believe that we should specifically focus and try to tailor such data spaces in a way that they can be conducive to innovation and competition while respecting the current regulatory framework. So thank you very much for your attention, and looking forward to our discussion.
Yes, thank you very much. I mean, to answer the last question, is there any questions? Yes, I'm sure, because I do have a few questions, but it will be Juliano turn to ask you some questions. But before that, I want to hear, and we all want to hear from Frédéric. So the floor is yours for another 15 minutes. And I believe that you want to share your screen. It's working. You need to unmute yourself. And we all hears.
Yes, it's fine. Do you see the slide, Thibault?
Yes. Can you put it full screen by any chance?
Full screen? Okay. Sorry. Hopla, sorry. Is it okay?
I think it's yeah.
Excellent.
It's not really full screen though.
Last test, perhaps.
Yeah, it worked.
You have to start the presentation.
Okay. Sorry, I make just.
Yeah, how do you start it? I'm not sure.
sorry, I will make the test. Is it okay?
So now we can see the screen, but it's not full screen. Indeed,
We will try like this if you want.
I mean, I think it's great like this.
Excellent.
It's just that, yeah, otherwise it's not a surprise what's coming next, and we want the surprise. So please go ahead.
Excellent. Thanks, Thibault. First of all, I want to thank the Brazilian Institute of Innovation and Competition for this innovation. It's for this invitation. Sorry, it's really a pleasure for me, and it's a pleasure to discuss with Laura, Juliano, and you. Like you said, I'm also a member of the French Competition Authority, but I will just present this communication as a CNRS researcher. I'm just in the authority in charge of the regulation of legal profession. So I have nothing to say officially about antitrust or merger controls. So on the field of the competition in digital markets, we have three possible questions. Do you see the second slide? Perfect. So the first question could be related to the difficulty to take given practices on the market, on digital market. I will take only one example, that is to say self-preferencing. After, in the second part, we will see how to combine, if it is necessary, how to combine ex-ante rules, sector-specific regulation, why not, and ex-post antitrust rules enforcement. Perhaps later in the discussion, we will speak about historical perspectives and need for academics for have a broader view on this subject. So let's start by self-preferencing. We have a lot of cases that involves self-preferencing. Google shopping case in the European Union in June 2017. Perhaps our current Amazon case with the statement of objections published by the DigiComp last October. And in all these cases, we have two main difficulties. The first one, how to characterize self-preferencing. And the second one, how to deal with such practices through only competition law enforcement. So, first point, if we want to analyze self-preferencing, we need to go back on the purposes of antitrust laws. Things are rather different in the US, in Europe, and I think in Brazil. Just consider the difference between US and EU. In the US, the position of the US Supreme Court since 1979 is very clear. The purpose of the Sherman Act is seen as a consumer welfare prescription. It is exactly the sentence of Robert Bork in 1978, 1 year before, in his antitrust paradox. But this view is very challenged. There is a challenge not on courtrooms, not before the US Supreme Court, but in the political arena, on the academic arena. On the academic sphere, see for instance the paper of Marshall Steinbaum and Maurice Stucke about the effective competition standard published in the University of Chicago Law Review this year. We can also consider the paper of Linehan, the paper of Webertland in the academic sphere, and we can see a tendency to propose to to go further this criterion, in the report of the subcommittee on antitrust, in the report of the Judiciary Committee published in October. What's the situation in the European Union? If we consider only the communication of the Commission in February 2009 on exclusionary abuses, we are in an effects-based approach with one criterion, the efficiency, that is to say, the consumer welfare. But we have also a legacy, an ordoliberal legacy. And within this ordoliberal legacy, we want to protect not the result of competition, that is to say the efficiency, I hope, but in fact the process of competition. And it is the reason for why we insist on the concept of a free and undistorted competition. Deriving or stemming from this concept, we had a notion, the notion of special responsibility of the dominant undertaking vis-à-vis competition. So this specific framework can lead to a specific view on self-preferencing issues. Just consider a very recent report from Philippe Marsden and Ruprecht Postdoen for the Konrad Adenauer Stiftung, that is to say the Foundation Konrad Adenauer, published last September, which was devoted to the balance in competition. So restoring balance to digital competitions, sensible rules, effective enforcement. And Philippe Marsden and Ruprecht Postdoen insisted on three objectives that can make sense regarding self-preferencing issue. First objective, freedom of competition, the liberty to access the platform, despite, eventually, the gatekeeper position of the dominant platform. Second dimension, perhaps more complex to address, the fairness of competition. That is to say, as soon as a player is both the manager of the marketplace and one player of the marketplace, how to ensure, if not a fair competition, an undistorted competition. That is to say, competition with a level playing field. And the last point, and even more complex to address, the sovereignty of actors to take their decision in an autonomous way. That is to say, the capacity to decide unilaterally. When we consider these different issues, these different concerns, we can say, okay, we have something to say, we have something to see about the issue of self-preferencing. But self-preferencing is a platform to business related issue. In fact, we can say we have a concern about the access to the market, or perhaps only the concern about the access on a given ecosystem. In addition, we are not in presence in each cases of an absolute dominant position. See, for instance, the case of Amazon is not obvious that Amazon enjoys of an absolute dominant position. Sometimes it can be only a relative dominant position. So this kind of concerns echo a notion that does not exist in the Treaty of Rome, that is to say the treaty about the functioning of the European Union, but that exists in member states' laws. It is the legislative provisions related to the abuse of economic dependence. It exists in Italian law, I think, in German law, in Portuguese law, French law, and in Belgian law since 2019. We can say, okay, a lot of our concerns about self-preferencing echoes the issue of economic dependence. So we have an economic or technical dependence vis-à-vis the keystone, that is to say, vis-à-vis the platform. So what are the issues? We can have something like exploitative practices or exclusionary practices to the detriment of complementors, that is to say, to the detriment of market players that need to access the platform to access the market. We have a lot of provisions in EU regulation. For instance, the P2B regulation of June 2019 about the fairness and the transparency in digital markets. But it is an issue of competition within the market and not an issue of competition for the market. That is to say, we need to address a lot of questions before analyzing this through the lens of competition policy. First, the degree of dominance, absolute or relative. The existence of barriers to entry on the market. If there is no barriers to entry, we have only to rely on competition for the market. We have also barriers to entries echo the notion of data advantage, technological advantage, and so on. We have also to take into consideration the issue of barrier to exit. Barrier to exit can echo the issue of interoperability, the issue of data portability, but also the issue of switching cost, specific investment, technological lock-in. So if we consider, I will go back during the discussion on this slide, but if we consider the two cases at stake in Europe, we have two very different cases of failure. We have,
excuse me, I think we are stuck on the slide number 3. I
oh,
thought it
sorry.
was that you were teasing us.
Oh, sorry. Is it like this?
I only see slide number 3. I don't know about Laura. Same, yeah.
I will.
It was really clear, so we didn't need the slides in any case. But
yes, but I think I have the solution, I hope.
Okay. And I wanted to tell you that you have 3 minutes left.
Okay, it will.
Yeah, now we can see. Okay.
Excellent. So I will present only, if you agree. Sorry, this one. Perfect. I will present only two cases, two European cases in the 3 minutes left. The first one, shopping, Google Shopping, and the second, Amazon. In self-preferencing, we can have two different strategies. The first one is to favor your own downstream subsidiary. It is an anti-competitive leveraging. So we have the same concern that we had 20 years ago, 13 years ago, with Microsoft, that is to say, demonstrating the distortion, the interest to make this distortion, and the effect on consumer welfare. So it is a case in which you leverage your market power in order to extend your monopoly position or to protect your upstream monopoly position. The case of Amazon is rather different because we have two different competitive concerns in Amazon. The first one is related to the asymmetric access to data, and it is related to the advantage that you can grasp if you access to data about your competitors when your competitors do not access to this data. So in this fact, it is an issue of a distorted competition, but we can see that we have a lot of cases like this in the retail industry, for instance, and with the competition between national brands and private label. Second point regarding Amazon, the issue of the buy box, how to win the buy box. And here, it is not an issue of extending your monopoly position, but an issue of favoring one downstream competitor against others. What could be the rational explanation of these practices? It can be something like an incentive to enter into exclusive contracts. That is to say, you give a premium to complementors, to merchants that are agree to enter in exclusive contract and so on, or that are agree to single home. But very last point, you have here, without slide, you are here a problem, because you have to supervise algorithm, you have to supervise contractual clauses, and you have to consider issues like economic dependence, issue like contractual imbalances, or issue like fairness. And it is very difficult to consider these cases only with the topical criterion of antitrust, which is the consumer welfare. I can perhaps stop here because the time is running, and we can speak about the different slides after in the discussion.
Yes, thank you very much once again. And I also have lots of questions that I wouldn't ask. Just one thing I want to say. I think we do need to organize a conference regarding ordoliberalism, because my way of reading it is, I'm not sure if it's the opposite or maybe complementary to your own, but for me, it's a school about reaching the end result of a particular market structure. And of course, for that, you need to have a competitive process. But I see it more as a way for the end result. And you said that it's more about the process. And yes, potentially they complement one another, but it might be a good subject for a conference, since
yes, it is clearly complementary. But sure, we have a lot of points to discuss about. It is only, in fact, about the relationship between Chicago School. That is to say, considering that the purpose of antitrust is allocative efficiency or consumer welfare, and the ordoliberal one, which is also neoliberal, but which put the accent on the process, considering that the process will lead inexorably to the result. But it depends on structure and so on. And I think we have a lot to discuss on this point.
Indeed, since it seems to be at the very center of the DSA, the DMA, the NCT, which we will discuss, but after Juliano comments on your presentation. So Juliano, the floor is yours.
Thank you, Thibault. So first of all, I would like to thank the Institute of Competition and Innovation for the invitation, and congratulate the Institute for the excellent conference that they have organized. And also, let me just, as Thibault has anticipated, my specific field of research in academics is on artificial intelligence, and in particular, the application of AI to law, and also the regulation of AI. In particular, I have been reading about these issues and the regulation of the interconnections between AI and data protection. But actually, I'm an antitrust lawyer. So these challenges that are brought about by the digital markets are joining these two activities together, or they're bringing them together. And actually, I learn a lot as an antitrust lawyer from both from the three of you. Thibault, Frédéric, and Laura. So it's an honor to have this opportunity to debate with you. So what I would have to comment first is actually the main driving force of the economy in digital markets is a combination of data plus intelligence. So it is intelligence upon data that creates innovation and furthers economic and further agents' positions in the market. In the discussions about how to handle this new force, driving force of economy, platforms has been emphasizing in their narratives that the main force is on intelligence, and therefore positions in their market are ephemeral. But what we have observed so far is that actually stability within the concentration of data is practically unsurmountable. And this has led to strong and dominant positions in the market. And actually, the narratives by platforms didn't match their practices in the market, because as Frédéric has emphasized, the practice of preferencing other practices like locking in an ecosystem are all means to achieve and to concentrate data or to hinder competitors to access data. So what they have been saying doesn't match with their behavior. And I have, as a lawyer, challenged, for instance, in Brazil, the case against Google Shopping. I have defended the Buscapé company against Google, and this is what we observe. The practice doesn't match the discourse. But now we have sufficient evidence of dominant positions, and we know that something must be done. This is a consensus. We don't know how to handle this challenge. And regarding intelligence, the platforms now are also using practices to affect the use of intelligence, even if competitors do not have enough access to data. For instance, by creating frictions and manipulating consumers by several practices. And so all that. Now I come also to Laura's presentation, and I would like also to congratulate both insightful presentations. All that touch in one point, which is individual sovereignty. Particularly, we are dealing with consumer sovereignty. But within the digital economy, the concentration of economic power is side by side with the concentration of informational power. And it's side by side with the concentration of political power. So the issues become much larger and broader. It has to do on how individuals would handle these concentrations of power, political, economic, and information, and how law is going to enhance not only consumer sovereignty in relation to economic power, but also citizen sovereignty in relation to political power, and also data subject sovereignty in relation to informational power. And that brings us to Laura, a very nice presentation, which was trying to call attention that there are different regulations that must be combined: data protection law, open data, and as well as antitrust law. And Laura has called us attention to the fact that it is difficult to conceptualize all these challenges to not only to consumer sovereignty, but also to data subject sovereignty, and also to citizen sovereignty, with the means which are provided by antitrust law. You see lawyers and enforcers trying to use antitrust box to apply to this central concept of what is data. And as Laura has shown, it's difficult to conceive to apply the essential facility doctrines regarding data because data, we use the analogy in some contexts that data resembles assets, but they are not actually assets as we are used to handle infrastructures or physical assets. And there are also conceptualizations of data as currency. And we have seen papers trying to construct a monopoly test, build a monopoly test in terms of data elasticity or privacy elasticity. It may make sense to some applications, but it doesn't work as a full conceptualization, and it finds some difficulties to application. So my question to both, given these challenges, which were very nicely presented by Laura and for Frédéric, both in trying to ensure competition within the market with traditional conceptualization of practices, or also by trying to unite antitrust law and coordinate it with the applications of other statutes about data protection, etc. My question is, what would be the solution? Would it be a new conceptualization of antitrust law, trying to reconceptualize in terms of this new driving force, which is data, and think about the role of informational power within economic power, within the conceptualization of economic power? Or should it be a strategy of a combination of institutes, so governance or organizational governance of authorities in the enforcement both of data protection and antitrust? Or should we have a brand new regulation of platforms, which is going to tackle with the several issues which are involved in these threats that this new business model by platforms is bringing, not only to the right of consumers, but to also to other fundamental rights. So this is the main question, and there is a question of the audience, and that I have already seen, which complements that, which is, for each of these alternatives, a new antitrust law, new conceptualizations in antitrust law, a sort of combination or a governance of authorities applying different statutes, or a new regulation of the platforms, do we have already enough information for this, for either of these alternatives?
Yes, well, thank you very much. Before I give you the floor, well, first of all, we have received 2 questions on YouTube, but one is exactly the question that you just asked regarding the information. But so I guess you are asking the 2 of them one main question, and if I may, I will add one sub question for each of you. Laura, I was wondering, when you show us the table with all of the regulations, first of all, I mean, it's incredibly helpful to have that. So thank you for providing us with that. And I was wondering if you saw some inconsistencies in those texts and what they provide us with. And for Frédéric, the question I would like to add, if I may, it's regarding the Google case. You mentioned shopping, and indeed, I mean, it has been said, and the European Commission is saying it, that it's a case about self-preferencing. But why is it not a case about discrimination? It seems to me that it's a school case of Article 101, paragraph C. So I was wondering if you have any thoughts regarding that. But please first answer Juliano question. And we'll give the floor to Laura once again, ladies first, of course.
Thank you very much, both Juliano and Thibault, for your very interesting comments. And I completely agree with Juliano general overview that, of course, we need intelligence combined to data to extract innovation, and the 2 debates are, close and should be addressed in a joint way. So the question that Juliano is asking us is indeed a $1 billion question. I mean, I think, you know, moving from the starting point of Juliano, we all agree that there are shortcomings in the current scenario. There are shortcomings concerning the current competition law tools. I mean, at least we can agree that as they are not covering a relevant role in the evolution of the market. But we can also ask ourselves if indeed competition law is the appropriate tool, or if we are discussing about policy-driven issues that should be left to regulation, while antitrust law as it is already has all the tools it needs to correct the market ex post. So my let's say my preliminary finding on that is that, in my opinion, the European Commission is indeed considering to, as we all know, is considering to move in the direction of ex-ante regulation. But when it comes to the role of competition law, we can all agree that still the role of competition law should be maintained ex post as a, let's say, branch of regulation intervening in case of firms' conduct that are indeed hindering competition and so on. So while I'm, let's say, I completely agree with the overview you provide us with, that there is a need to change the framework, and that we cannot consider the economic power without also considering the information power, without also considering the political power and so on. It looks to me that the role of regulator is the leading one in this scenario. I mean, we need to go through policy driven decisions, while in my perspective, competition law should still maintain the role of correcting the market if needed ex post. So while I'm much more, let's say, understanding all the debate concerning the gatekeeper power of platforms and all the debate concerning the need of, let's say, increasing transparency and so on, I'm much more reluctant when we discuss about changing the competition law tools. Also linking this comment to the second question we received on YouTube, because I'm not fully sure that a market failure has been specifically framed. What I mean is that, you know, if we decide to introduce new competition law tools, if we want to keep them, let's say, impartial, so not policy oriented, we should fully understand what is really needed first, and then elaborate the tool per se. So while I'm much more following with much attention the debate on regulation, and I think we can consider the opportunity of policy-driven decision in this field, I have doubts concerning new competition tools. Why? Because I see the risk that they can be oriented, I mean, not impartial as we usually perceive competition law, as indeed a branch of regulation just pursuing interest of, as that Frédéric also framed very well in his presentation. So that's just to say that I have not an answer to your very, very interesting and broad question, even though I strongly believe that we should go in a direction of combining all the tools we have. And answering to the question we received on YouTube, I think that there are, of course, instruments that the Commission is using to understand how to better regulate digital markets and so on. However, I can feel the reason why this question makes very much sense is that we should expect, let's say, the demonstration of a market failure first, and then the formulation of a piece of regulation. And this is something that, due to the nature of digital markets, data economy, and so on, we're kind of missing. I mean, it's much more easy to have a sectoral regulation in a specific sector where we have a specific market failure that need to be corrected, while in this overall scenario, a lot of questions are still open. And to answer to Thibault's question, indeed, one of my, let's say, main findings is that I fully understand the reason why the European Union decided to proceed with a sectorial piecemeal approach, because of course different interests are on the table. We are discussing about, and again, I'm linking this also to Juliano's comment, we should also consider individual sovereignty, we should think about all the interests on the table. However, this piecemeal fragmented approach indeed is creating a scenario which has some contradictions. Or better, once you consider that the majority of the data sets are mixed, so they contain data which are personal, non-personal, private, public sector information, and so on, being compliant with such a set of rules can be extremely difficult, and can also be extremely difficult really to understand what is the set of rules we have to comply with. And of course we have inconsistency because for some set of data we have rules that push toward the direction of increasing the access. Think about public sector information, while in the case of personal data, in order to respect individual sovereignty, we cannot move in this direction. So the result is a really difficult and not homogeneous regulatory framework. I understand the reason why, but it's just to address, your comment on this. So I will maybe stop my comments here now.
Well, thank you very much. And I mean, indeed, so it's very interesting to know that you find some inconsistencies when it comes to, even for the way companies have to comply with all of those regulations. The reason why I was asking the question was also regarding the inconsistencies for regulators. And an example that comes to mind is that we hear sometimes that we should break up companies. And I mean, the case that was introduced yesterday against Facebook in the United States is a good example. Okay, and we also hear that we should force big tech companies to provide access to all of their data. But it seems to me that if you break up a tech company, then forcing access is much more complex, because you have to ensure, that 10 new companies are providing access instead of just one. So I'm not sure sometimes if we shouldn't choose one direction instead of trying to push the two. But I mean, I think we are getting to a framework that will be great for my questions and the second part of the panel. But before that, I want to give Frédéric the floor to answer Juliano's question. And if you have time, my little question.
Thanks, Thibault. I will answer some of the questions of Juliano. I'm fully agree with you. One, our concern is related to data, but not only rough data. The data at stake, in fact, as personal data, non-personal data collected by ecosystems, but also data observed through the behavior of customer user in this ecosystem. And the broader the limit, the more diversified the ecosystem, the most valuable your data. It is 4V of data: veracity, volume, variety, and volume, veracity, variety, speediness, perhaps, donc velocity of data. In fact, the most diversified you are, the better your data. And after, it is an issue of deducing new data. That is to say, how to analyze data, how to develop an intelligence through this data. And a lot of acquisitions, for instance, Onavo by Facebook, Looker by Google, is exactly, or are exactly, in this area of business intelligence. That is to say, it is not the data that provide the competitive advantage, it is your algorithmic capacity to treat this data in order to predict tendencies, to predict consumer behavior in the future, and so on. So in fact, there is a strong connection between the data and the technical capacity. You're perfectly right. And if you have a data advantage grounded on your capacity to analyze data, you can preempt markets. You can identify very soon market opportunities, or perhaps market threats, in fact. You can make some preemptive acquisitions, why not? So in fact, the issue of data, it's really central. A second issue that you stressed is the one of political objectives of antitrust. When I say political, is non-exclusively economic objectives of antitrust, like media pluralism, like the link between the concentration of market power and political power, and so on. In the history of antitrust, at the very origin in the United States, there were a close link between the dispersal of economic power and the dispersal of political power. It is something like a Jeffersonian view. You cannot have a democracy if it is not a democracy between equals at the economic point of view. And we find here the notion of sovereignty of Philippe Marsden and Utrech post-du. So, in fact, the concentration of economic power raises several questions. Efficiency, it is not clear that we have damage in terms of efficiency. I'm not sure, frankly speaking. Perhaps a consequence in terms of inequalities, in terms of fairness. Perhaps it is an hypothesis that we can read frequently in the literature. But there is also a question in terms of democracy, in terms of access to information. And here, frankly speaking, when we enforce competition rules, we can take into considerations notion as pluralism in the media, for instance, but it is not, in fact, the core job of competition rules. If you want to have broader objectives than allocative efficiency, perhaps the competition rules are not the best placed to realize these objectives. And it echoes to a third question, in fact, the question of the evolution of antitrust, the evolution of competition policy regarding the issue of digital markets. We have, in fact, three phases. The first one, we continue the business as usual, ex post, and we analyze the compliance of practices with antitrust rules, and we make a balance between bad consequences for competition and potential efficiency gains. The issue and the debate is first, are the fines sufficiently high to deter bad practices, for the question? And the second one, can behavioral remedies restore competition? We have these two questions, in fact. The alternative, the first one, rely on ex-ante rules, like do or do not, with, in fact, two questions, two risks. We can have something like a competitive capture from other firms in order to specify the obligation, that is to say, obligations in terms of data access, obligations in terms of capacity. So there is this risk. And if we consider the negative rules, the don't, we have a risk to stop innovative process. That is to say, to hinder the access to the consumers of innovation and so on. So in fact, it is something like a cost-benefit analysis. We have a risk of error in antitrust adjudication, false positive, false negative. But if we set this kind of rule, the economic calculation, in fact, is an ex-ante one, but with rigid rule. So it can be the first point. Second point is to make antitrust evolves toward something like a British regime, like the Enterprise Act of 2002, with the model of market investigations. When you make market investigations, you can propose remedies, and these remedies can try to tackle a structural failure of competition, that is to say, to play on market structure or to obtain far-reaching behavioral remedies. It can be possible, and it can be performed, in fact, by the competition authority. The last way to address this issue is to rely on a sector-specific regulator, like in natural monopolies, like in public utilities. The regulator can take into consideration broader objectives, pluralism, efficiency, economic equilibrium, and so on, but it's supposed to access constantly to information. It's supposed to be really able to collect information, to analyze information, and to forecast the trends of the market. We can have two concerns. The first one, a lack of capacity to supervise the market, to direct this market, and the second one, the difficulty to supervise firms' behavior. For instance, we spoke previously about Google Shopping. In Google Shopping, it is very difficult to analyze algorithm, the correcting algorithm, to see if this correcting algorithm only aims at correcting farm clicks, search engine manipulation. In that case, it is to the benefit of consumers, to the benefit of users, or if it induces a market manipulation. So it is very difficult, in fact, to make this monitoring, this content monitoring, except monitoring on only a very specific platform. See, for instance, the case of UK with Google and Facebook. So I think we have a very, very broad range in terms of regulation. And to end with Thibault remark about shopping, you're right, we can call this a practice or discrimination. I agree.
Okay, thank you very much. And so you almost answered the question that I wanted to ask you, but you certainly answered the question in the chat about the goals of competition and whether or not we have enough information, but still I want to come back to that. So now we're moving on to the second part of this panel, in which I will be asking the three of you 3 questions. And we will actually change a little bit the way I wanted to do it. And we will start with Laura and then Juliano and Frédéric for the first question. So the first question that I want to ask you regards, and again, I don't want to be Europe centric as sometimes they are in the US when they are US centric, but I still think that it will provide us with a nice framework to think about ex-ante rules, and most specifically about the new competition tool, the Digital Service Act and the Digital Market Act. Those two will be announced, so we are told, in December the 15th. So we do not have the text yet, but we do have the consultations, and we more or less know what they are. And so it has been said that they will include a list of do's and don'ts. And to me, to tell you the truth, when I first was teaching competition law, I wanted to start the class and giving my students a practice of Article 102, which was always anti-competitive, because I thought it would be a nice way for them to understand what is anti-competitive. and I had a really hard time finding a practice that is always anti-competitive. So my first question is, do we have enough information to actually make such a list? And regarding the structure of markets, because apparently those acts want to tackle that as well, do we have enough information regarding which structure of the market is best, whatever the objective is, whether it is for consumer welfare, for innovation, for protecting democracy, any of the objective? I'm wondering if we have enough information. So again, we will start with Laura, and if you could keep your answers in 3 to 4 minutes, that would be great, so we can go through the list.
Of course, I will try to be quick, and you know, somehow your question is kind of related to what we discussed till now. Indeed, we don't have text yet, even though we have all understood that the approach of the Commission is indeed in the direction of providing us with do's and don'ts list, and looks like the idea is that regulation can be seen as a good tool to, let's say, set the ground for fostering the data economy, digital markets, and so on, and also for, let's say, preventing conducts, or at least marginalizing conducts that could distort competition. So my reaction to the specific question Thibault made is, do we have enough information? Do we have enough data to, let's say, identify such conducts? I have to say that my first reaction was exactly the same you were mentioning. It is extremely difficult, if we make an effort, to write down what conducts are always anti-competitive. Of course, we can find agreements with a couple of them in specific scenario, but just to say that let's try to make this exercise together of identifying specific conducts that should be seen as always anti-competitive when they concern digital markets, when they concern the data economy. I have to say that, in my opinion, this is an incredible theoretical exercise. And if we look, for example, to the findings that the public consultation on the Digital Service Act provide us with, and we think about the gatekeeper power of platform, just as an example of the several measures the Commission will soon adopt, I think we can all agree that still a case-by-case assessment is kind of needed. So my point of view is that, of course, if there is a need of a policy interventions, we cannot postpone it forever. From the other side, I have this perception that all the information and the data collected are not providing us with, let's say, a unique scenario that can fit to rules that really provide us with do's and don'ts. So just to focus on the last part of your question, and maybe I will leave the floor to my colleagues, and then I will go back to other points.
Yes, thank you very much. It was very precise answer. Juliano, and again, I don't want to be Europe-centric, so it's more about, you know, the concept of do's and don'ts rather than the DSA per se.
Okay, well, but actually the idea of a blacklist boils down to some per se rules which would be specific to digital markets. And I have two concerns about it. The first one is that per se rules become a hard law, not a flexible one, and they can be over or under inclusive in their conceptualization. Even if we have your question, do we have enough information to do this? We could have, we cannot have infinite information of all the peculiarities where these practices can be, and all the contexts that this practice may be done by dominant firms or within the market. So I'm afraid of some inefficiencies in this approach, considering a changing and very complex environment. But I think that my main fear, which is the second point, is has to do on how some per se rules in the digital antitrust may affect antitrust in general, because as I see law as a corpus of our integrated rules. So we have concepts which are interconnected within a coherent whole. So we already have examples of changes in a field of law that affect others. For instance, a change in the labor law in the beginning of the 20th century by recognizing and acknowledging that labor law is not based on selling working force as an asset, has changed and has affected, for instance, antitrust law by the Clayton Act that exempted unions from the enforcement of antitrust. So these ideas are connected, or other idea, the concept of economic group or power of control that has been enlarged by antitrust has affected corporate law. So these concepts are connected. It's an illusion to think that we are going to create rules for digital market that are not going to affect antitrust as a whole. I see already, for instance, CADE, in some case, they are applying tools that are raised in the discussion of the digital markets. They are applying to infrastructure sectors. For instance, avoiding definition of relevant market, applying some flexibilization of the idea of essential facility to physical infrastructures. So I believe that authorities are going to change the way they enforce antitrust law as a whole. And that means a move to a per se approach. That's what I'm afraid of.
Yeah, and I mean, it's fascinating and also partially answer my third question, but I can see already how helpful it could be to have such a study, to take one of those texts, DSA, DMA, and to try to see how this will impact all of the other fields of the law. I haven't read anything yet. I mean, of course, we're still waiting for the text, but this should certainly be fascinating. So thanks
I have also proposed to a student of mine to try to analyze CADE's new or more recent cases where they apply ideas of digital or concepts developed to antitrust in digital markets to traditional markets.
So yeah,
I have seen in my practice that this is already happening.
If you could push that students to publish both in Brazilian Portuguese and in English, that would be great. So we can actually access that, because I think this will be very valuable. So I will give now the floor to Frédéric for the same question.
For 20 minutes, Thibault?
25. I give you 25.
Okay. Yes. No. I will play the role of the devil's advocate for per se rules. I think we are all agree. An ex post assessment of the practices is necessary, especially in the digital area, in which we have a huge uncertainty about the effect of the practice, and where is very difficult to forecast the future. Ex post, we can make an assessment, but in fact, it is a case-by-case analysis and ex post. But here I start my role of devil's advocate. We had recently a paper in the University of Chicago Law Review in 2020, in the same issue than the one of Marshall Stenbaum and Maurice Stucke, of Ruit Chopra and Leinakan. And Leinakan and Ruit Chopra proposed to go back to per se rules on arguments like the complexity of an ex post assessment, the cost of the procedure, the cost and the duration by naturally, and perhaps, if I may add a point, we can say if we make only an ex post assessment, perhaps we will have damage to competition, and our tools, the fine, the behavioral remedy, or the structural remedy, if it is possible, I do not know, may be insufficient to restore the level playing field. So per se rules can be possible only if we can we anchor an irreversible damage to the market. That is to say, the competition in the market will be impossible after. Just an example, see a branch jurisprudence, case law, sorry, in the US in the 60s. That is to say, we can go to say, okay, if I acquire one of my competitor, even if I have a market share of 15% and my competitor of 1%, perhaps it is the start of definitive damage to the structure of competition. So again, it is very difficult to define market practices as bad by nature and to be forbidden, and on the other hand, market practices good whatever the conditions. So in fact, we have just to be first pragmatist, second empirist.
I mean, the brown shoe, I can't resist but to say that the brown shoe decision, in the opinion, they do say that it will actually raise prices, but that's okay because they were going for another objective. And this is what Herb Ovenkamp has been saying about the neo-Brandisian, right? That it will raise prices and won't benefit consumers. Two things that I want to say. I've done the study regarding per se rules and by object in the EU, although it's not the same. And it actually takes longer, those proceedings, because the courts want to make sure that the practice fits within the box of per se rules and by object. And that is a process that takes actually longer than studying the effect. And I mean, the idea of complexity, of course, is one that I think we should discuss because we're not discussing complexity enough in the field, but I'll leave it to that. I will move on to now the second question. And for the second question, we'll start with Juliano. My second question is the following, short question, very hard to answer. If you could ask one question to policymakers, you could choose whatever policymaker you want. What question would it be and why would you ask that particular question?
Well, I think it will not be a question, but a warning that the problem will not be tackled or solved only with antitrust or only with data protection, but with a more broad and general view on regulation. And this has to do with the question with my comments. I really believe that the problem of concentration regards not only economic power, but also political power and informational power. So we must remember that the platforms, they became the public infrastructure of communication. And so they affect the construction of the public sphere. So it's the very public sphere which is endangered. So that means that there are also other fundamental rights, not only the freedom of commerce or right to the consumer's right, but also fundamental right to privacy, information self-determination, and even democracy. So what I think is that I would ask regulators that you should not only look at some of the consequences, but also to really look at the causes. For instance, the idea of making this blacklist is attacking the consequences. No? And actually, these are consequences of two goals by the platforms, which is accumulate data and prevent competitors from accumulating data, and also trying to avoid innovation by competitors. So I think that a regulation that goes to the causes of the problem should do something in the direction that Laura has pointed out, such as creating mechanisms for mandatory access to data, interoperability, data separation within ecosystems or within economic groups, transparency related to algorithms, minimal privacy policies that should be mandatory. And normally these measures are treated as remedies that should come after after successive infringements of these blacklist practices. But I think that actually this is remedying the consequences. Actually, we should have a general regulation of platforms where these issues are faced and discussed. And of course, it's not easy because there is the risk of compromising the business model. But actually, within a framework, economic agents, they will find other business model to explore the market. I believe in that. So I would go through the causes and attack more general problems that affects not only the freedom of trade, but also other fundamental rights.
Yes, thank you very much. So, I mean, I guess to put it in the form of one question, it could be, how often are you talking with, you know, all of the other regulators, even within the same country? Because of course they say they do, but are you talking about the causes indeed? And, you know, is it on a daily basis, weekly basis, monthly basis, or yearly basis? It might be the case in some countries indeed. So thank you very much for that.
I agree.
We'll move on now to Frédéric for the same question. One question,
yes, and,
policymaker.
Yes, and in fact, roughly speaking, the same response. In fact, we are sometimes too focused on antitrust matters. That is to say, distortions on the market. But in fact, it is necessary to avoid the silos. Just two examples. The first one. There was 1 month ago a consent decree in the US between Zoom and the FTC. And in fact, it was related to encryption, to security of users with some deceptive practices, alleged deceptive practices from Zoom that can impair the security, for instance, on Apple devices. And there were two dissent, the dissent of Rebecca Slaughter and the dissent of Rohit Chopra. The dissent of Rebecca Slaughter insisted on the link between security concerns and privacy concerns. The dissent of Rohit Chopra insisted on the links between security concerns and competition concerns. In fact, deception can distort competition. We see with the case of Zoom, we are today on Zoom, that some practices are not only an issue of security, not only an issue of privacy, not only an issue of competition, but the third. In addition, second point, we stop immediately after, we are not, when we speak about Amazon, we are not exclusively on the marketplace. Amazon has vertical integration in logistics, in computing capacities, and so on. So in fact, we have the tendency to reduce all this ecosystem to only one service: Amazon, a marketplace, Google, a search service, Facebook, a social network, and so on. We need to understand the business model of this firm to properly not regulate them, but to understand their market decisions. And without this, it is impossible.
Yeah, and I mean, to that, I was thinking about it recently, and I thought to some degree it makes sense because they were all new to us 10 years ago. So it makes sense to say platforms, you know, it was a way for us to grasp all the subject. But potentially the time has come for us to now start making distinctions even within the same company, or to also have a look at the evolution of companies, right? Because they also change their business model, so they could be named the same. But I've learned recently that Samsung started in the business of selling fish, actually. It was not a tech company. So it's very interesting to see how they shape their services, even within the same company. So thanks a lot for that. Now, Laura, what is your question to policymakers?
Thank you. That's a very interesting question. And I have to say that my answer, or better, my question, again, I'm very EU-oriented, I think, due to my presentation of today. But I have to say that Juliano kind of spoiled it, because my question was indeed asking the EU policymakers if they consider or are evaluating to go toward a more holistic approach. So trying to have all these pieces of regulation speaking among themselves and trying, to systematize them in a way that can be indeed seen as a unique regulatory scenario, as maybe is happening in other sectors. So my question is very much close to the comment of Juliano. If I can, considering that Juliano already explained this very well, I would be then curious maybe to ask the UK policy maker that recently, we have seen the statement from the UK government about activating a specific digital unit within the CMA and a new code to be applied. So I would be very curious to understand what is the final goal of such, UK strategy. So considering that Juliano already asked my question, I would refer to the UK CMA/UK government to better understand what is the final goal of this digital unit and digital code. And it's very interesting if you check the announcement, the statement of the government to tackle platforms such as Google and Facebook. So it's really kind of a strong statement, and I would be very curious to better understand the rationale. So maybe I would take the opportunity to discuss with them this specific idea.
Yes, thank you very much. So it's not impossible actually that some of the agencies are watching us. If I may compliment, regarding the same question that it seems that the three of us want to ask regarding how does competition policy fits with other policies, if they do consider other objective, I will be very much interested in hearing about the preferences. Because if we do not know the list of preferences, then it seems that you could actually take this objective in that case, this objective in that case, and in terms of legal certainty, it's not ideal. But on the other end, if you give the list of preferences, it will create some issues, right? If we say, oh, we always prefer privacy rather than competition, well, that will be interesting to discuss, or vice versa. So again, more work ahead of us, but if regulators are watching us, you can interact with us on Twitter or by email. We will be pleased to be asking you more questions. And we move on to the last question of the day. Please also, if you watch us on YouTube, we had a few questions. Feel free, now is the time to answer questions so we can answer after this one. The last question I wanted to ask you, and we'll start with Frédéric to answer it, is regarding the work, and especially empirical work, that you think we need the most to understand digital competition better. And it leads me to ask you what you think as an academic community we could do, or what should we do, which type of studies you wish when you do research that you could actually reference to. So that's the question I'm asking you, and the floor is yours.
Excellent, thanks Thibault. In fact, according to me, is a two-step process, or two different things. The first one is perhaps to consider not only law and economics, like we do since the 70s, to go to law and strategic management in order to understand the business model. In fact, I learned more in reading my colleagues in management science than sometimes in industrial organization. Why? Because their awareness about business model. And I think there is something very important to consider this field. A second field essential to consider is data science. Juliano spoke in his intervention about consumer manipulation, that is to say, how to manipulate consumer preference with bad nudges, how to create frictions like bad sludges and so on. That is to say, we cannot understand how algorithms run without any dialogue with data scientists. That is to say, we need to understand what we spoke about. So I think it is the first things to do, to open to management science and to open to data science. And the second one is in fact history. just because our questions are already known, in fact, in the field of competition law. I remember a paper of Daniel Crane that Thibault has made me discovered, I think 2 years ago, no more. It was a paper of Daniel about the US presidential campaign in 1912. In fact, it was a campaign with 4 candidates, just very quick. Webb's a socialist who wanted to nationalize the trust. Roosevelt, a progressist who wanted to regulate the trust. Big companies, big government. Wilson, a Democrat, that want to complement the Sherman Act with the FTC Act, the Clayton Act, and so on. And Taft, the Republican, wanted just to enforce the Sherman Act. When we see the political context before the First World War in the US, it is exactly the hour, in fact. There is nothing new. The technology is new, but not the question. So it is the second way.
Yes, thank you very much. If I may briefly comment regarding the first point, so I suspect that you do not find enough literature in the field of antitrust which cross with management sciences and this type of stuff. If that is indeed your perspective, this is definitely mine. And I very much agree with you that we need to understand what's happening within the firm, and we need to leave a little bit our level of just looking at the firms from above. Regarding the historical perspective, I want to say to all of our listeners and people watching us on YouTube that you first published a paper, which I think is terrific, on the history of the law and economic schools recently, but I'm not sure if it's yet published. You will publish, or I've published one about Justice Brandeis. I'm not sure if it's available.
Not still published. It will be presented Friday in seminar.
Okay. So for everyone, just keep an eye on Frédéric Twitter feed. And regarding Daniel paper that you mentioned, indeed, it's a fascinating paper. I forgot the title, but it's also showing that in that campaign, Roosevelt was discussing antitrust quite a lot, and that's entirely disappeared from US presidential debates until the last election, pretty much. So it's fascinating to know and to see that we are doing a pendulum movement regarding the issues which are important, and as you say, new tech, but pretty much the same issues. Yes. So I encourage everyone really to read your work in the field.
I have the title of the paper of Daniel.
Please. Yeah.
All I really need to know about antitrust, I learned it in 1912. It was published in 2015 in the Iowa Law Review. Fascinating.
Perfect. Yeah, and it's open access.
Yes.
So thanks a lot for that. Now we move on. Same question to Laura. So what empirical work would you need or wish that we could have, and what do we need to do as an academic community?
Yeah, first of all, I completely agree with Frédéric's perspective on the need of having, let's say, more strong dialogue between lawyers and real business entity. And I think the comment on business model is really a fitting one. I remember when I first presented my research on data sharing at the Max Planck Institute for Innovation and Competition, the guys from the economic part of the institute start asking questions about, how the commission, for example, identify all the obstacles to data sharing. So what do they mean with the lack of interoperability? How we want to define the market for data? All these questions that indeed, of course, require some regulatory background, but in order to be fully addressed, they need an assessment of the business model in use, the market, if any, because we should also discuss if there is a market for data and so on. So this is just to say that my first reaction is indeed that even more than ever, when we discuss about digital markets and data economy, we need a coordinated research from different branches, which include, of course, law, but that should include also economics in a broader perspective. And if we want to answer the question in a more, let's say, antitrust oriented point of view in a more, let's say, our specific scientific community, I maybe think it is the time to go for an updated empirical analysis concerning the scope and the effects of the current competition laws. I mean, of course, the European Commission finance a lot of studies to address how competition law is working, and also through the public consultation, we have a lot of results. But I remember that once in a while, we really have competition law scholars that take the challenge of addressing from an empirical point of view what is the effects of competition, what are the effects of competition law, and I truly believe that it makes sense also to reopen such a possible stream of research.
Yes, thanks very much. It makes me think about a book which is very controversial, so you should read it with some perspective. It's called The Antitrust Religion. And it's actually arguing that in absence of empirical study, then all we have is a religion, right? We believe that competition is good, we believe it is not. And if we could leave the field of religion to move to the field of science a little bit, why not doing it? But without further ado now, I'm very much looking for your perspective, Juliano, coming from, again, both the field of AI and competition. I suspect it might be what you would like to see more, but maybe you will actually need to see more of another type of work. So the floor is yours.
Well, my background is mainly on philosophy of law, and then on logic and artificial intelligence. So I'm not very keen on empirical studies, except I'm very inclined to studies about concepts and conceptualization. So, but actually, some empirical work, of course, I think empirical work is quite important. And for instance, as I've suggested my student, it's a sort of empirical work, but actually to check how the Brazilian antitrust authority is enforcing these new concepts. But I surely agree with Frédéric that studies, interdisciplinary studies, gathering lawyers and computer scientists or data science is urgent, so that we can have a stronger and more rigorous approach to understanding this core technology and also the very idea of data. As we have discussed, data is quite in the center of the whole discussion, be it the data which is generated, be it the data which is observed or created by the use of intelligence. And by intelligence, we mean technological tools to infer more data. So it's about technology and data. These are the driving force. So we have to have a more precise conceptualization of it. And by that, I also mean a legal conceptualization or a legal theory that encompasses all these perspectives and implications of these business models upon data, so that we can get rid of these imperfect analogies and have a coherent theory about it. I think that this conceptual effort is quite important for the very enforcement of law.
Yes, thank you very much. And you know, it makes me think the way you approach the subject, starting with the legal philosophy and then moving to the field of AI, is actually what Lawrence Lessig did as well, right? Before he wrote code, he was actually a constitutional scholar. He is now back to the field of constitutional law. But it makes me think also of the work of Leibniz and, you know, all of the legal philosophers, because if you study AI, quickly you will find yourself into the field of what's the law, what's the purpose. I think we do not have any more questions, but here's a surprise, and I didn't warn you about that. We have time for one last question, but please be very brief. We will be doing it a bit like a presidential debate. I will be giving each of you 1 minute to express one message that you will need or you would like to leave our audience with. So again, I'm putting you on the spot right now, but if any one of you want to start, please feel free to to speak out. So again, what would be the number one message you would like to leave everyone with? Who wants to start?
Maybe I can start.
Yeah, sure, thank you.
Just, I think, our panel was on competition law and digital markets, competition law, innovation and digital markets. And I think that the main message that resulted from all our approach, the four of us, is that, of course, competition law should remain a separate field than ex-ante regulation, and that the two of them should be complementary in a sense that while competition law should keep its leading role in approaching the market and the dynamics exposed, regulation can indeed policy orient the digital markets in a policy direction that still makes very much sense. And the second very quick message is that I think we all agree that the European Union is making a quite relevant job in this field, and that maybe a more, let's say, holistic approach can help both business entities and the academic community and the research industry and so on. So these are the two, let's say, key messages I think we can take away with us after this session.
Okay, thank you very much. I'm told we're out of time, but so I will give you just 30 seconds instead of 1 minute.
Yes,
Frédéric, please.
I can go for 20 minutes again. No, just 2 points. One, in one of the slides of Laura, it was a sentence, competition law has not to intervene on the structure of market. And when we consider the inception impact assessment of the EU Commission, we spoke about structural failure. And in that case, it is very difficult to restore the competition through structural remedies. What we have to do is to restore the competitive process, that is to say, to favor the competition for the market. And favoring the competition for the market supposes to sustain innovation and to sustain disruption, and not to enact rigid rules.
Yes, thank you very much. Very clear. Juliano, the last word is yours.
Okay, well, I would say that digital markets are actually the new infrastructure of public communication. So more than ever, the antitrust policy must be considered in connection with other public policies regarding the public information and communications, free speech, privacy, and democracy. So a broader view on antitrust policies, which are regarded also with other relevant policies and public values.
Yes, well, thank you very much. You said one of my favorite words, infrastructure. I think indeed it's key in the field. I'll leave it to that. I would like to, first of all, to thank you. I think the format was great. We had the time to discuss, and I've learned a lot, and I'm sure everyone did. I also would like to thank the organizers. It's a wonderful conference, and we are very lucky that you put so much effort in organizing all that. So I think it's time for us to leave the floor to other subjects. I look forward to discussing the subject with you in the near future, and I'll wish you a great weekend, and I'll see you soon.